of the Supreme Court of Appeals are now saying that all persons having motions to make an appeal to prosecute them before we shall be heard. God save the state of West Virginia and this honorable court.
Good morning. Will the clerk please call the first case?
Yes, the first case for argument this morning is under Rule 20, Goldstein versus Peacemaker Properties and Peacemaker National Training Center, docket number 170796, and this is an appeal from the Circuit Court of Berkeley County.
May it please the court. My name is Joe Cartwright. I represent Ben and Diane Goldstein. Mr. Goldstein is seated here in the courtroom with me. Mrs. Goldstein was not able to attend due to her health. Mr. and Mrs. Goldstein are here on behalf of all of their neighbors in both West Virginia and Virginia who suffer from excessive noise from the respondent's shooting range, a collection of over 17 shooting ranges that opened in 2011. This case is about peace and quiet. The right to every person for peaceful enjoyment of his or her property. It's a right we all enjoy. It's a right protected by the United States and the West Virginia Constitutions. I'm sure many lawyers have probably through the years pointed to the quote above us, but it applies directly in this case. The true foundation of Republican government is the equal right of every citizen in his person and property and in their management. And we're here asking this court to consider Mr. or Mrs. Goldstein's equal right in their property and its management. That right is protected in West Virginia by the common law of nuisance, which requires every property owner to simply use their property reasonably, to be respectful of others' rights. That right is also protected by the statute at issue in this case, 61-223 as amended. The main legal issue for the court is whether our legislature intended to abolish the protections for West Virginia property owners' peace and quiet provided by the common law of nuisance when it amended this statute. The answer to that question is no. It did not intend to abolish unilaterally and completely our protections as property owners. There's an important condition contained in subsection E of the statute adopted by the legislature. The circuit court erred because it didn't even address this condition, a condition that balances our rights as property owners with the rights of other property owners who want to operate a business, a shooting range, a rock concert, whatever it may be. The legislature struck a balance with subsection E, which the condition reads that there's immunity from action for nuisance if the shooting range is operating in compliance with all ordinances relating to noise in effect at the time construction or operation of the shooting range began. That condition is important. It tells us what the legislature's intent was. The circuit court held.
Counsel, can we ask one quick question? Obviously, the legislature amended this statute just a couple of years ago. The F says clearly the intent of the legislature in enacting the amendments during the 2017 regular session that they are to be applied retroactively. Do you challenge at all the retroactive application of this statute? What statute is controlling for this husband and wife's claim? The statute at the time that they purchased their property, at the time when the gun range was open, or following the 2017 regular session?
The statute can be applied retroactively, but
so
it can't be unconstitutional.
You don't challenge the retroactivity of the statute?
Please don't misunderstand. The legislature clearly made this statute retroactive. However, there are limits to the legislature's power to do that. The legislature cannot sweep away vested rights by making a statute retroactive. Here, Mr. and Mrs. Goldstein filed their claim within time under a previous statute that allowed them specifically both equitable relief and monetary damages. They pled both. Even if this court were to determine that the statute is to be interpreted under the more absolute, extreme interpretation advanced by the respondents, and there were no prospective relief for injunction going forward available to Mr. and Mrs. Goldstein, they would still be entitled to their claim for monetary damages. That cannot be swept away by the legislature retroactively. That's due process. That's our Constitution. When we're trying to gauge what the legislature intended with its amendment to the statute, we need to look at what the legislature said first, because it's presumed to mean what it says. It did not say, as the circuit court determined, that 61-223 as amended retroactively prohibits nuisance actions against shooting ranges. It wasn't that absolute. This condition is very important. It demonstrates intent. And it gives it provides an either-or proposition that provides balance in our law and respects a property owner's right to the management of their property. It says either a shooting range should comply with an ordinance if one has been adopted that applies to them, or they comply with the law of nuisance and they're expected to act reasonably and respectfully toward their neighbors. In addition to the condition itself in the statute, the note to the legislation when it was proposed gives us an indication of the legislature's intent. The law tells us that a sponsor's intent is authoritative. And the sponsor to this bill, in a note at the beginning of the bill, told us the purpose of this bill is to limit, not prohibit, limit nuisance actions against shooting ranges for noises. There's more important language in that note. The bill prohibits ordinances regulating shooting ranges. Here, Berkeley County has an ordinance, but it doesn't regulate shooting ranges. It exempts shooting ranges. It's not the type of ordinance that was addressed by this statute.
Well, is it your contention that the shooting range is not operating in compliance with the ordinances relating to noise that were in effect at the time the construction or operation of the range began?
The shooting range is not in compliance with an ordinance because an ordinance does not apply to them. The Berkeley County ordinance provides that they are exempt.
Was that in effect at the time they opened the range?
The Berkeley County ordinance was adopted in 2007 and amended in 2009, and yes, it was in effect long before the legislature amended this statute. What's important about the ordinance, and I would call to the court's attention, is that it specifically says those who are offended by violations of this ordinance may avail themselves of any legal remedy available to them, notwithstanding the fact the violators may have been charged and convicted of a misdemeanor pursuant to this ordinance. So when the Berkeley County Council adopted this ordinance in 2007, it contemplated that we would still have our rights under the common law of nuisance to protect our peaceful enjoyment of our property. It was only 10 years later, when the legislature amended this statute, that there was any question about that. The county council certainly intended to preserve the common law of nuisance and those remedies for property owners. They simply exempted, which means that the noise standards do not apply to shooting ranges. But it's interesting what the legislature did say in its intent in the discussion of the bill. The Senate Judiciary Committee counsel explained that this bill was intended to limit the applicability of county and municipal noise ordinances as they affect shooting ranges. As they affect shooting ranges. The Berkeley County ordinance doesn't affect shooting ranges. The council also said, as they affect shooting ranges, two noise ordinances and levels therein. Clearly, some noise level was contemplated to apply to a shooting range. Either the noise level set in the ordinance or the noise level that would be required by a reasonable person, the standard set by a jury in a nuisance case. So even the counsel to the Judiciary Committee acknowledged that this statute was intended only to address ordinances that affect shooting ranges. The lobbyist who spoke when this bill was presented didn't mention at all the abolition or prohibition of the law of nuisance. The lobbyists simply said, we don't want the rules to be changed in the middle of the game. So the legislature's intent should be derived from what was presented to them. And here, there was no indication at any point that the legislature intended that this statute should eliminate any noise standard for shooting ranges. And that's important because that's the main legal issue, of course. The respondent here advocates the more extreme view that the circuit court, we contend, erroneously adopted. The absolute view that the statute retroactively prohibits nuisance actions against shooting ranges without any reference to this condition, without any reference to the balancing condition that they must be in compliance with some noise standard that applies to the shooting range. The legislature is presumed to say what it means and mean what it says. That's the law. If they had intended what the circuit court found to retroactively prohibit nuisance actions against shooting ranges without any conditions or balancing language, they would have said so. They didn't. That's why that condition is so important. The respondent also wants the court to ignore the practical effect of their extreme view of this statute. There are 10 counties in West Virginia that have noise ordinances, 10 of 55, of course. 5 of the 10 that have noise ordinances exempt shooting ranges. So only 5 of the 10 counties that have noise ordinances would have any protection for people and their property rights. The other 50 counties, 5 counties that exempt shooting ranges would have no protection under the respondent's interpretation, and 45 counties would have no protection if this court were to determine that having no ordinance that sets a noise level equals compliance with all ordinances in effect at the time. So the practical effect that the respondent advocates would leave people in 50 counties in this state without any protection for their cherished right to peaceful enjoyment of their property. That's not, we submit, what the legislature intended. The respondents have indicated this through their brief when they've argued the West Virginia statute does not have a requirement that a noise ordinance be in existence for a range to be in compliance and therefore immune. We don't believe that that's what the legislature intended, or it would have said so. It would have been more absolute in its language, and it would have not included a condition that required compliance with some noise standard. The respondent also wants this court to ignore the constitutional problem created by retroactive application of the statute. Respondents agree a statute may not be applied retroactively if it takes vested property rights in violation of due process. The respondents agree that a claim for monetary damages is a vested property right which cannot be taken without due process. The only way around this offered by the respondents is just simply that their suggestion that Mr. and Mrs. Goldstein didn't adequately plead a claim for monetary damages in their complaint. Now, I would say Mr. and Mrs. Goldstein's complaint certainly emphasized the relief that was available to them at the time, which included injunctive relief. Mr. and Mrs. Goldstein care mostly about their peace and quiet, but they certainly pled a claim for monetary damages as alternative relief, as permitted by Rule 8. The law on this, though, is even more determinative and rebuts the respondent's position. The law says, and I believe this is the Gibson case, that an accrued cause is a vested property right. Certainly, Mr. and Mrs. Goldstein had an accrued cause of action when they filed their complaint in 2015. Legal relief. They sought legal relief specifically, legal and equitable relief in their prayer of their complaint. Legal relief is monetary damages. The respondents simply gloss over that fact because it doesn't fit their argument. More importantly, I suppose, West Virginia is a notice pleading state. We know that. Our rules are designed to achieve substantial justice and have cases determined on their merits. Here, there's no question that the respondents had notice of Mr. and Mrs. Goldstein's claim for monetary damages and therefore their vested property right, which cannot be unconstitutionally and retroactively taken. Mr. and Mrs. the respondents specifically ask in interrogatories in our case, 18 and 19, tell us what your monetary damages are. They knew up front, and we told them. It includes diminution in value of our property, annoyance and inconvenience, those types of damages. They also acknowledged, the respondents also acknowledged to the district court in a separate deck action where they asked for insurance coverage for Mr. and Mrs. Goldstein's claims. They specifically asserted in the district court, we want coverage because they claim monetary damages. So there's no question here that the respondents have notice of Mr. and Mrs. Goldstein's claims, and those claims for monetary damages can't be swept away retroactively. We are asking the court to correct 3 rulings by the circuit court. The grant of summary judgment based upon a misapplication of the statute and an improper expansion of the statute. The circuit court did not even in its order analyze the meaning of 61-223 and the specific condition that's intended to preserve some noise standard applicable to all West Virginia property owners. There's no discussion in the court's order of what it means if a shooting range is in compliance with a local noise ordinance. The circuit court also did not analyze Mr. and Mrs. or acknowledge Mr. and Mrs. claims for monetary damages. The circuit court didn't do any constitutional analysis of the effect of retroactivity. And to your question, Justice Jenkins, a statute can be constitutionally retroactive, but in its application be unconstitutional. And that's what we have here. When this statute is applied retroactively to Mr. and Mrs. Goldstein's case, it is unconstitutional because it sweeps away their vested rights, their claim for monetary damages, and their protections for their property rights. The circuit court didn't address that at all, and that was an error.
You've got a couple other questions that are concerning me a little bit. As I understand, the petitioner's property is in Virginia, is that correct?
It is.
And so they would have the right to try and enforce a nuisance cause of action in the Virginia courts, would they not?
Well, that's a question. We examined it. We determined that because Peacemaker lies primarily in West Virginia, it has approximately 40-some acres that lie in Virginia and maybe one shooting range of the 17-plus in Virginia, that the West Virginia court would be the court with the most obvious jurisdiction to enjoin nuisance. So we filed our claim in West Virginia, where the court would have jurisdiction over the defendant, Peacemaker. We also filed a separate companion action in Virginia based upon the same nuisance and based upon the jurisdiction that the Virginia court would have over the property that Peacemaker has in Virginia.
What's the status of that case?
That case was put on hold. I believe it's been non-suited at this point. But the point is that, and Virginia has a similar range protection statute, they call it. And it brings us back to the same arguments about whether that statute would prohibit Mr. and Mrs. Goldstein's claim in Virginia when there is no noise standard applicable to their zone in Frederick County, Virginia. But we determined that the West Virginia court was the best court with the most obvious jurisdiction over Peacemaker to enjoin its excessive noise.
I think we understand your position. Let's hear from the other side, and you'll have a chance for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court. We would ask on behalf of Peacemaker National Training Center, Peacemaker Properties, that both circuit court decisions as related to the range protection statute and as related to the discovery issues in the case be affirmed. We think Judge Wilkes got it right, and if I would allow, I would like to address some of the questions that were raised on direct. Justice Jenkins, as far as what statute applies, as far as the respondent's position, the statute that was passed in July of 2017 would apply in this case. And that then gets to whether or not it can be applied retroactively. And we absolutely think it does, and here's why. First of all, the law, I think, is clear that a statute, you first have to defer to the legislature and the intent, whether or not the legislature intended that statute to be made retroactive. Clearly, there was an express provision that it was intended to be retroactive. Then you have to ask the question, was there any vested property rights for petitioners? The law is clear that there is not a vested property right in a cause of action seeking injunctive relief, and that's what we have here. if you look at the relief sought in the petitioner's complaint, it's a lengthy paragraph, and it asks for several varying things, all injunctive relief. And
Then why did you ask about their claim for monetary damages in discovery?
well, Your Honor, certainly through the discovery process is comprehensive, and it's intended to encapsulate potentially anything that the petitioners could raise during the case. And so we have a full picture of the case. But the fact that it was not properly pled, that's our position, gets to the point that they were only seeking injunctive relief. The monetary damages that are sought in the request for relief are only monetary damages if an injunction was put in place and if Peacemaker violated that injunction. That's expressly what they've asked for. And for that reason, there was no vested property right in this action. I would also note, and I think the Court has taken judicial notice of the companion insurance defense case that was filed in the federal court. There has been a final determination in that matter by Judge Groh, who determined that there was no right to a defense or indemnification. And the opinion written by Judge Groh specifically found that in the underlying lawsuits, the Goldsteins seek equitable relief, specifically temporary and permanent injunctive relief, and therefore it's clear that they don't seek damages. And so a federal judge has determined, based upon her analysis of the complaint, that there was not a clear claim for monetary relief. And for these reasons, getting to your question, Justice Jenkins, this statute absolutely can be applied retroactively, and it does not impact the petitioner's claims here. Justice Workman, as far as your question as to whether or not the Peacemaker was in compliance with Berkeley County, Berkeley County expressly exempts shooting ranges.
And that was in existence at the time
it was.
That the shooting range was started?
It was indeed. And nationwide, these range protection statutes have been challenged nationwide. And what's interesting about this case with this state and this range is that there is an express exemption in the local noise ordinance. And because it is exemptive, there is an exemption, it is indeed in compliance. The cases cited by both parties on both sides nationwide are situations where there is absolutely no noise ordinance in place.
Well, what about his argument that it's an unconstitutional taking of the petitioner's property in the sense that they no longer can have peace and enjoyment of their premises?
Well, and I think that gets to the whether or not it completely abolished any protections that the petitioners may have in this case, and I think the petitioners further argue then the modifications of the amendments to that statute are absurd somehow. And I would note that the absurdity doctrine states that it has to be demonstrably at odds with any conceivable legislative purposes. But here, the legislature clearly intended to delegate the authority to local counties. They didn't abolish common law nuisance statewide. They said, we're going to give the counties the opportunity to enact whatever noise control standards they deem fit. And that's what they've done. The survey that petitioners performed statewide as to what counties have noise control ordinances in place, I think is telling. In our state, I think that there are only 5 counties, Jefferson, Berkeley, and Morgan, all the Eastern Panhandle, and I think Summers, where there is a noise ordinance in place that also exempts gun ranges. There are, I think, a handful of other counties, 4 or 5, that have noise control standards in place that don't provide express exemption. And so, looking statewide, this statute did not abolish common law nuisance statewide. It allowed the counties, and it allows the counties to make whatever local noise, to put out whatever local noise standards in place that they intend and would desire. And again, it's clear, the law is clear that the legislature has the right to abrogate common law. And the law is also clear that the legislature has the right to delegate its authority to the local counties. Under Chapter 8A, under Chapter 7, it's clear that the counties have control locally as to their standards.
If we were to find that the plaintiff has in fact adequately pled damages, then your position is that he could go forward on common law nuisance?
If the court were to find that damages were, that monetary damages were properly pled, then I think in that case, the petitioners may be able to proceed only on their request for monetary damages and only during a very focused amount of time. In that case, you're only dealing with a temporary nuisance and not a permanent nuisance because the legislature has modified that clearly.
Well, but what you're admitting to us here today is that the exemptions applied by the statute do not abrogate the common law for nuisance.
Correct.
Okay.
Correct. I mean, it delegates the authority to counties, and in Berkeley County, clearly Berkeley County has exempted gun ranges. They've decided to do that. They've taken that step. I would also note this area where this gun range is situated, the most southern property line in the Berkeley County, is the most rural area in Berkeley County. And I would only assume that the Planning Commission, when they approved the range, took into consideration the rural area that they were dealing with. And so those factors had to be considered when this range was approved and it was allowed to operate.
Can I follow up just a moment on Justice Hutchinson's question to you about the effect that this statute has on common law nuisance claims? The Section E1, the statute says the operation or use of shooting ranges may not be enjoined based on noise, nor may any person be subject to an action for nuisance or criminal prosecution. Do you believe that language relates to common law claims as well? Because I think you said that it doesn't abrogate common law. So I'm trying to understand your argument of how the two relate one to another, common law nuisance claims and this and a prosecution under this statute for a nuisance claim.
What the statute does, again, the legislature does have the authority to abrogate common law. I mean, I think that's clear. What this statute does is, again, it delegates that authority to the counties. And so it allows the counties to put in place whatever noise control standards they desire. And in this case, in this county, in Berkeley County, it very well indeed will have abrogated the common law in Berkeley County. But it doesn't do so statewide. And it doesn't do so in a sense that would make that statute and that amendment unconstitutional, somehow deprives citizens statewide of their rights. The interplay with Berkeley County is that Berkeley County has acted based upon however they see fit within its county. They've acted and they've put certain noise control standards in place, and they expressly exempt gun ranges. And that's so in this case in Berkeley County, indeed it has abrogated, but Justice Hutchinson, to your point, it has not abrogated it statewide. It allows the counties to make their own determinations.
Would the effect in any county that doesn't have a noise ordinance, or a county that had a noise ordinance that exempted gun ranges, would the effect be to abrogate common law nuisance claims in those situations?
Well, I think the cases, the range protection statute cases nationwide indicate that this still, even in the absence of a noise control standard, that this statute would apply. And I think in the situations where you have where you have noise controls that that don't exempt gun ranges, then obviously you'd have those standards in place. But again, I want to fall back on the fact that the legislature has ceded that authority, that delegated that authority to the counties to make their own determinations.
Well, in this case, then, if you're saying that Morgan County, because they've exempted gun ranges from their noise ordinance have effectively abrogated common law nuisance because of their, I think that's what I heard you say.
Or Berkeley County, and Morgan County as well.
Berkeley. You said
Berkeley County, I'm sorry, Berkeley County. So then we step back to the issue of can a statute that is intended to be retroactive erase a vested claim?
And on that point, I'm taking a look at the language in Judge Groh's order that you referenced a little while ago,
yes.
And I want to challenge you a little bit on your characterization of that. In the order, as I see it, she says, the Goldsteins request noise abatement measure be implemented on the shooting range if Peacemaker fails to comply with the injunctions. Furthermore, if these forms of relief are not complied with, the Goldsteins request monetary damages for the cost of implementing reasonable and necessary noise abatement measures on their own property. That sounds like a claim for monetary damages.
Well, I would say, can I ask what page you're referring to? And I don't know if you could reference it, but I have it in front of me.
Star 1 of the West.
I would say two things. One would be that request, and that is how it's framed in the complaint, is if and only, we interpret that to mean if and only if there is an injunction in place and it is somehow violated. And if you look at the request for relief, that's what the petitioners have asked for. Should the defendant still fail to meet these specific guidelines, right? So what guidelines? Guidelines that would have been in place through an injunction. The plaintiffs respectfully request this court award monetary damages for the cost of implementing reasonable and necessary noise abatement measures. So it seems to me that that's only asking for damages in the event that the injunction fails. And it's not a separate and distinct claim that was properly pled initially for injunctive relief or monetary damages.
Isn't that the very essence of pleading in the alternative?
Well, yes, I don't think that was done here appropriately. I think that it could have been, and I also note the petitioners at any point up until the judge granted summary judgment could have amended their complaint to make it abundantly clear that they were seeking a separate claim, an independent claim for monetary damages, assuming they couldn't get their injunctive relief. I would also note that under Judge Groh's order, it states specifically in her findings, in the underlying lawsuits, the Goldsteins seek equitable relief, specifically temporary and permanent injunctive relief regarding the hours of operation and maximum noise levels. If the Circuit Court of Berkeley County, West Virginia, or the Circuit Court of Frederick County, Virginia, order for Peacemaker to comply with an injunction, and Peacemaker fails to comply with such an injunction, only then do the Goldsteins wish to seek further relief. Therefore, in the underlying lawsuits, the Goldsteins do not currently seek damages. And so Judge Groh read it the same way that we're presenting it to this court.
Under your theory, then, it's an impossibility for an injunction to issue in this case because of that statute, right?
Correct. And I think the law is clear that that's permissible.
So then Peacemaker would not be required to adhere to any kind of standards, and so the only thing left for them would be monetary damages.
If this court finds that monetary damages were properly pled, right, then yes, Goldsteins no longer have a claim for an injunction. The legislature has clearly determined that. And their monetary damages, I would argue, would be limited to a very specific time frame, assuming they can so prove the nuisance. I don't know if
you could wrap it up. I think
the justices want me to address the discovery dispute. I think that's fairly clear. The Circuit Court clearly had the discretion. Judge Wilkes didn't abuse his discretion. I would just note, if you do look at that order that was adopted, it was granted in part and denied in part. And there are several provisions that the Discovery Commissioner and then ultimately Judge Silver did not give the petitioners. And so in that case, an award of attorney fees is clearly in the discretion of the court.
Very good, thank you.
Thank you.
If I may begin with the last thing we discussed and work backwards. I didn't address specifically the discovery dispute in the opening argument. I will say simply that the title of the order that said it granted in part and denied in part Mr. and Mrs. Goldstein's motion to compel was a misnomer. We've laid out in extensive detail, and I apologize for some of that detail, the discovery dispute. And you will see that every part, the discovery commissioner and the court granted every part of Mr. and Mrs. Goldstein's motion to compel. The only thing that wasn't explicitly granted was one request where Peacemaker said, we've given you everything we've got. And that's when they were offering us about 40 pages of documents. And the discovery commissioner said, well, I'm not denying your request, but if there's more and you discover it, you can have it. Not a single one, not a single part of Mr. and Mrs. Goldstein's motion to compel was denied. And that's important because under the rule, an award of fees is mandatory when the motion is granted unless there's some substantial justification for the dispute. With regard to the discovery dispute, the court originally granted Mr. and Mrs. Goldstein attorney fees because of the intransigence in discovery that Peacemaker offered. They didn't acknowledge public documents. They didn't come forward with information that was clearly relevant, like the addresses and names of witnesses. And they drugged Mr. and Mrs. Goldstein through tens of thousands of dollars of discovery wrangling before they even got basic information. Like, yes, we have a computer database. Yes, it identifies the people that shoot at our shooting range. Yes, it's public. We don't want to give it to you because we think there's confidentiality involved. That's the epitome of bad faith. The circuit court, in reversing its decision, committed clear error, abuse of discretion, because it was wrong on the law and wrong on the facts. And that's why we've asked this court to look very carefully at the discovery dispute. Because when you look at the detail and look at what Mr. and Mrs. Goldstein had to go through just to get simple, basic information that's regularly mandated, they had to spend tens of thousands of dollars to do it. Now, I want to back up to the discussion of the vested property right and the notion that Mr. and Mrs. Goldstein have not pled a claim for monetary damages. First and foremost, I would say that the prayer of Mr. and Mrs. Goldstein's complaint contains a final sentence. It's typical. The plaintiffs requests any and all additional legal and equitable relief that the court may find proper. And that's intentional, because legal relief is monetary damages. So not only is their claim for monetary damages mentioned in the previous paragraphs where it's pled in the alternatives and conditioned upon the entrance and noncompliance with an injunction, it's pled at the end of their prayer. The respondent has suggested that they did make it abundantly clear that they were making a claim for punitive damages, or excuse me, a claim for monetary damages. But we know under West Virginia's notice pleading statutes, that's not the standard. We also know unequivocally that the respondents were well aware of the claim for monetary damages, and that's what the pleading standard requires. That's what makes that, and also the fact that an accrued cause of action is a vested property right, is why this statute can't be applied retroactively to Mr. and Mrs. Goldstein. The great irony here is that the statute upon which Peacemaker, the respondent, relies was ostensibly offered or adopted to avoid changing the rules in the middle of the game. And now here, Peacemaker, the respondent, suggests that Mr. and Mrs. Goldstein should have their vested property right taken away by changing the rules in the middle of the game, by pointing to a statute that changed the rules in the middle of the game. That shouldn't be. That's not what the legislature intended.
You've both done an excellent job at fleshing out these issues, and the case will be submitted.
Thank you, Your Honor.
Thank you.
The next case for oral argument, the West Virginia Department of Transportation Division of Highways and its Secretary Commissioner versus Victor Morton Eccles and others, docket number 180226, and this case is before the court on certified question.
May it please the Court, my name is Leah Chappell, and I represent the West Virginia Division of Highways. I'd like to reserve 5 minutes of my time for rebuttal, please. Your Honors, this case arises out of a condemnation relating to Corridor H, which, for better or for worse, Corridor H has been before this court several times. This case presents an opportunity for this court to address several, I believe as many as 5, substantive issues of law that routinely appear before circuit courts in this state, but which have never been specifically addressed in a way that can prevent future reversible error. To that end, I have taken what I know is the somewhat unusual step of proposing that the 3 certified questions be reformulated into as many as 5 certified questions. I hope in my reply brief I adequately explained the reasons for that and why. I believe the certified questions as presented to the court unfortunately incorporate multiple topics of law which, when put together, presume a conclusion on one topic before one can answer the second topic. So that is the reason for the proposal of the multiple certified questions. Okay, the first topic that I'm hoping the court will address by way of a reformulated certified question is when condemnation of part of a property, a landowner's property for public road purposes eliminates pre-existing public road access to the residue of the property, does the property owner have the right to disapprove DOH's designation of alternative public road access, which DOH determines best serves the traveling public? The answer, I think, to that is clearly no. West Virginia law allocates or places upon the state of West Virginia the burden of every phase of deciding what is in the best interests of the traveling public with respect to public roads. That's everything from the original determination that the public needs are not being met all the way up through the final construction of a road. And West Virginia Code Chapter 17, Article 4, in multiple sections, lays out all those various responsibilities that are placed upon the Division of Highways. However, nowhere in any of those statutes is any entity, whether it be a circuit court, a jury, or a property owner, is any entity other than the state of West Virginia given responsibility for any of those actions. The property owner, when a public road is designed or constructed, the property owner is entitled to money damages. On this, the landowners and the state agree 100%. They are not entitled to a say in how the road is designed. So to the extent that this case appears to be in a peculiar posture, it is. Once construction was completed, and this actually isn't that uncommon, I can tell you that from experience, but once construction was completed, it became apparent that what were previously believed to be private road or private easement accesses onto the residue were not, in fact, available to the property owner. This wasn't discovered until construction was completed. So I'm going to allow for the possibility that if the state decides to construct an alternative access, there's going to have to be an amendment of the underlying petition. There's going to have to be new right-of-way plans filed. And as the court is aware, there are a great many times a case goes to trial when the road is not yet constructed. So a jury makes their determination typically off the petition that's filed and the right-of-way plans and then the anticipated end result of construction. So we don't have to wait around for 4 more years for more construction to be done before the case could go to trial. So the reason that the state is proposing certified question number 1 is to put to bed, hopefully for this case and for future cases, the question of whether any entity other than the state of West Virginia plays a role in any aspect of designing and constructing public roads. And we believe the answer to that is no. Now that said, we move on to the question of DOH's obligation to restore access when access is taken. Petitioner's proposed reformulated question number 2 raises the question of whether DOH has the option of restoring public road access to the property in order to mitigate damages to the residue as long as that access is reasonable. Now, the question of access is always one of reasonableness. Going back to the 1964 case of State Ex Rel. Woods versus State Road, and coming up to as recently as 2008, following an adverse verdict, the Holiday Inn in Parkersburg, which was Parkersburg Inn, Inc., challenged a jury instruction that was given, which instructed the jurors that when a property owner acquires property in the state of West Virginia, he does so in tacit recognition that the state of West Virginia may, within its discretion, change the public road access to that property. However, the jury was also instructed, and this court approved that instruction, that a jury may consider whether that access is reasonable, and based on the jury's conclusion of what the answer is to that question, may award damages to the residue. So the question of reasonableness is one for the jury. The question of how roads are to be constructed is not. So because Judge Courier's orders indicate an intention to seek input from the jury by way of special interrogatories as to whether a certain parcel was an uneconomic remnant or whether access in the after is reasonable. This is why the state is proposing the number and variety of certified questions. I think these questions are squarely raised by the orders that have been entered by Judge Courier, expressing his intention of how to conduct the ultimate trial of this case.
Well, did you seek to have the lower court reformulate the questions?
No, Your Honor. I got this case, I'm not underlying trial counsel. I was only asked to handle the appeal. To my knowledge, both sides were asked to provide proposed questions, and then the court certified its own questions. So with request...
Counsel, you, under the deeming something on the reasonableness, is the cost, as the respondents have raised, is the cost of maintaining the road that the DOT, DOH might have done for mitigation, would that be factored into the reasonableness of the DOT, DOH's mitigation efforts?
Yes, Your Honor, it would. And I think that's addressed actually fairly directly in proposed reformulated question number 5. That's where we get into cost to cure. And as the court is aware, whatever DOH's cost is of constructing a road, that's their problem. That's their cost. But cost to cure relates to money that should be paid to the property owner to cure or fix problems arising on the property, either directly or indirectly as a result of the road construction. So I absolutely would envision...
So future maintenance of the replacement road would be within the costs that the respondents would be entitled to?
I think that is likely, as long as it is justified by proper disclosure and discovery and admissible for all other, under all other criteria. Let me give the court an example. If the state is going to take out a transmission line for a gas well, but not the gas well itself, then the state pays a cost to cure to replace or relocate the transmission line. If the court or if the road project is going to hit a belt line that accesses a coal mine, state doesn't have to pay for the whole coal mine, they pay to relocate or reconstruct the belt line. So there, and that is an ongoing, that could be an ongoing expense for a gas well operator or a coal mine operator that the jury would have to consider when deciding how many dollars are needed to cure the problem created by road construction. So with respect to reformulated question number 3, the question that DOH proposes the court reformulate and answer is the question of the exclusive authority of the Division of Highways to determine what constitutes an uneconomic remnant. Here we're looking at 42 U.S.C. 4651 parens 9, which places in the West Virginia Commissioner of Highways the exclusive authority to determine whether the condemnation of property for public road construction leaves a property owner with an uneconomic remnant on projects where federal money is involved, and whether it is the province of the trial court then to make a legal or factual finding that a landowner is left with an uneconomic remnant. The answer to that is no. The federal statute is very clear, and I'd like to point out to the court that it was amended in 1987 to add language that vests in the head of the condemning agency the discretion to determine whether a residual parcel is in fact an uneconomic remnant. Now, Let's keep in mind that that language is part of a comprehensive statutory framework, which also places upon the condemning agency significant responsibility to make sure that the interests of the property owner are protected.
Well, so you would leave it just to the administrative head to unilaterally make that determination rather than the property owner having the right to have this considered by a jury?
I'm not saying the property owner can't have it considered by a jury. I'm saying that the specific determination of the uneconomic remnant is by statute vested exclusively in the agency head.
By federal statute?
Yes.
Okay, but does that apply to the context that we're talking about now?
Absolutely, it applies in all cases. It can't not apply because West Virginia is obligated to follow all aspects of the Act. And I think you'll find that there are very few, but there's at least one federal case on point that indicates that judicial review of the agency's actions of this nature are not, that Congress intended to preclude judicial review.
So the answer is yes. You want the DOH to be able to determine unilaterally what the uneconomic remnant is worth.
No, ma'am. Whether it is an uneconomic remnant. That is the only determination that's specifically addressed in that part of the statute. And then at that point...
And what kind of standards are there for that determination?
It doesn't say.
So it's whatever the administrative head determines.
It's a binary decision. It's either yes or no that it's an uneconomic remnant. If the agency head determines that it is, then at that point, that triggers the agency's obligation to offer, not condemn, to offer to buy the property. That will undoubtedly be done at the value that has been set by the appraisal that was hired by the Division of Highways under the same statute. The property owner is free to reject that offer. However, the property owner is not precluded from seeking damages to the residue at trial. I want to make it clear, our position on this is very narrow. We're only talking about the specific finding and designation of an uneconomic remnant. Whether the state does or does not make that designation only relates to the state's obligation to offer to purchase the property. The property owner is at all times still free to take the position that there is a residue that has suffered economic damage for which just compensation should be awarded.
And you are not then contending that that federal statute precludes them from seeking those kinds of damages?
I think there is no language in the federal act or the state law which would limit a property owner's right to seek whatever damages that property owner thinks are appropriate. And at that point then, the circuit judge fulfills his or her role as gatekeeper when it comes to admissibility of that sort of evidence. I'd like to point out when it comes to a determination of whether property has utility in the after-taking scenario, there is every scenario available that you can imagine, everything from black to white and every shade of gray in between. The property owner could allege that the property should be valued at 0, and therefore 100% damages should be awarded to the property owner. The property owner's appraiser could concede that because the diminution in value relates only to, say, topography or certain types of utility rather than public road access, that the damages to the residue are only 50%. Having done this for 17 years, I've pretty much seen every range of possibilities you can imagine. But our position is that the federal statute designates one and only one entity to make the determination of uneconomic remnant. That by itself is just a very specific finding that triggers the obligation to offer to buy. It in no way obligates the property owner to accept the offer. It in no way limits the property owner's rights as found under the West Virginia Constitution and the laws of the state of West Virginia. The right to a commissioner's hearing, the right to a trial by jury, the right to an appeal, the right to all the other benefits that are available under the federal statute, such as relocation costs, the hiring of relocation specialists. I mean, I want to make it clear that under this statute, yes, our position is that the state is vested with sole and exclusive authority on that one point. However, the state has many, many responsibilities to property owners under the statute, which are the trade-off for being given sole and exclusive authority on certain matters. So we think it is very important, given the posture of the case below, it's very important that this court speak to the question of what role the federal statute plays on this particular topic. Otherwise, I can nearly guarantee you're going to see this case
So the
again.
commissioner in this case has said that that is an economic remnant.
I'm sorry?
The commissioner has declared in this case that what we're talking about, the remnant, that it is an economic. It's not worthless.
That is not, no, well, again, there's only one finding. Either the commissioner says nothing at all, or the commissioner says it's an uneconomic remnant.
Right. Okay, so has he made that determination?
He did not, and I think one of the reasons for that is that, like I mentioned at the beginning, it didn't become apparent until construction was complete that the private rights of ways both the state and property owner thought would provide access to this property did not, in fact, provide access. So this case is actually still in an intermediate posture. Decisions need to be made about whether to amend the petition and construct an alternative access. The state has made proposals, but there's been apparently no final decision made on that.
If you, in terms of determining, as you mentioned, the landowner would have the ability to seek damages in terms of just compensation in relation to the residual, the remainder.
Damages to the residue.
Isn't that done basically at the time the condemnation takes place? And I guess I'm trying to determine if you then create a road to that property, are you trying to then in fact change what basically the outcome of that just compensation would be? I mean, is that what you're trying to do? Is you're trying to say, without that road, there may be more damage than there would be that they would be entitled to with the road? Is that what you're trying to get to in terms of having the Department of Transportation be able to make that decision whether you build the road or not?
In theory, the state always makes efforts in its design process to minimize damages to the residue of property owners' land, especially when you've got a particularly large parcel as you do here. In a typical scenario, all parties would have had knowledge that after the taking, that no public road access would exist to this northern residue. And the DOH would have taken that into account in their original design process. So yes, to the extent that the state does try to minimize damages to people's property, which then has the practical effect of minimizing the amount of money that has to be paid, you got that 100% right. It failed in this case because the absence of additional access to the property was not apparent to, I don't think, to any of the parties until the construction was complete and neighboring property owners said, nope, you don't have a right of way across my property, you're not getting on through me. And that's when everybody kind of went back to the drawing board on the access issue.
So you really then have basically two choices in that case. You either go back and build an access road, or you pay damages for the fact that it's no longer accessible. I mean, is that...
Yes, the state either designs and builds an alternative access, or they don't.
So is it your position that that's your decision as to which route to go? And if so, what role does the landowner, should the landowner play in that decision?
That's a little tougher to answer in the exact posture this case is in because it probably should have gone to trial already and hasn't. But normally, our position is all questions of the design and construction of public roads are squarely within the authority of the Division of Highways. Whatever decisions they make, good, bad, or otherwise, the jury then may consider those right-of-way plans, that construction, when deciding how much money a property owner is entitled to for the value of the property taken and damages to the residue. So whatever state decisions DOH makes, they're stuck with them at trial. There should be no question at trial as to exactly what the road construction and the right-of-way plans show.
But now, are you, perhaps you've answered this and I just didn't grasp it, but are you saying that if the landowner rejects a proposal for an access road, that what rights does the DOH have then?
Well, if the DOH...
Because the lower court said if they rejected it, then they had the right to go before a jury for damages for the remnant.
Right. There are no circumstances under which a jury should be asked to consider whether a property owner's position on road construction is reasonable or unreasonable, because, with all due respect to property owners, they have many rights, but the right to veto power over the design of roads is not one of them.
Well, I'm talking about the access road.
You're talking about two different things here, though. You're talking about the road, quarter H has already gone through.
I'm talking about the access road.
Yeah.
Yes.
And that's the second thing you're talking about. You're saying that the property owner has no right to veto DOH saying, okay, we're going to come up over here and build you a road to give you access to that property. You're saying that the property owner has no right to say no.
They don't. And I'm sorry, Your Honor, there is simply nothing in the statute that provides any entity other than DOH with the authority to determine what road design and construction serves the best interests of the traveling public. That said...
Now, once the DOH determines what they think is a reasonable access, does the DOH then maintain that road?
If it is a public road, of course, DOH always has the obligation to maintain it. Let me make sure we're talking about the same thing. I'm talking about DOH effecting road construction on property on which it has a right-of-way. I am not talking about about DOH entering on to the property owner's private property on which no condemnation has been filed. If DOH determines that it needs to alter the road construction plans, it may need to move to amend the condemnation petition to properly provide for all property that has to be taken, temporary construction easements, even to put a stub onto the property owner's land. If DOH enters onto property that it doesn't already have a right-of-way on, it has to amend the petition. What I'm talking about is
once the DOH's plans result in parcel being landlocked, there is an obligation on the part of the DOH to either provide alternative access or to compensate the people for the fact that their land is unusable.
Well, once DOH makes final decisions about road construction, and the case goes to trial and a jury considers whatever the actual construction is that's been done, or perhaps amended right-of-way plans, then whatever dollar amount the jury considers to be just compensation, then the questions are answered. It's done. The jury doesn't consider questions of future maintenance of roads that DOH has constructed on its own right-of-way. I'm just saying that whatever decision DOH makes, that when it comes to a jury deciding what just compensation to pay, DOH has to live with its own decisions. And that's for the protection of the property owner. There should be no gray at trial about what road construction is either done or is being proposed.
Counsel, let's give you an opportunity. Obviously, the respondents have cited a couple of cases, and obviously the questions have made it pretty clear that this question of whether or not the people would be compensated in monetary damages, or if they have the right to reject that suggested the way in which DOT doing a replacement road. And the question is that respondents have cited the Board of Education versus Canal City, Schaefer, and the B&O Railroad versus Bonneville errors as promoting the suggestions that they are entitled to compensation for damages. Can you explain why those cases don't apply here and are not a basis for their ability to recover damages?
The state doesn't disagree with that, with those propositions. When a condemnation case goes to trial, a jury is expected to, for all intents and purposes, answer one question. What is just compensation due the property owner for the value of the property taken and damages to the residue? At that time, the jury should consider only the right-of-way plans on which condemnation has occurred. So we don't disagree. The property owner is entitled to 100% of whatever just compensation a jury decides is appropriate under the construction scenario then before the jury.
But they don't have, if I understand you correctly, they don't have to have a right, under your contention, to invade the question of whether landlocked property is an uneconomic
Uneconomic remnant is simply an administrative determination.
Exactly. So they don't have any right to, on your purview, to seek any compensation?
No, that's not what I'm saying at all. The property owner, neither the court nor a property owner has the right to infringe upon the agency's exclusive discretion in determining what constitutes an uneconomic remnant. That determination is merely an administrative determination, which triggers the government's obligation to offer to buy the property at whatever value the state has determined is appropriate through its appraisal process. None of that has anything to do with the property owner's right to seek whatever level of just compensation it and its experts deem appropriate given the circumstances of the residue as they exist at the time of trial.
But what if the DOH decides that it's not an uneconomic parcel, that it's still
The property owner still presents their evidence. They still bring their experts. They still put on all their evidence.
So they do have a right to seek damages?
Absolutely.
If the DOH makes that conclusion?
Regardless of DOH's action on the question of uneconomic remnant, the property owner is still free to seek damages to the residue if he or she has evidence to support such a claim. The uneconomic remnant is merely a very limited finding that triggers the obligation to offer to buy the property. If DOH does make that finding, but offers an amount of money the property owner isn't happy with, then, in my experience, the appraiser, the DOH's appraiser, will be asked at trial, isn't it true DOH made a finding that this is an uneconomic remnant? Yes. We just disagree about perhaps the percentage of diminution in value that should be applied, or perhaps what those dollar amounts are. For instance, in this case, Kent Kiesecker, the state's appraiser, valued the property at $2,100 an acre, and Mr. McClurg, the property owner's appraiser, valued it at $3,500 an acre. The jury will hear that evidence and decide as a matter of fact what just compensation they deem appropriate, which appraiser they agree with more, and what percentage of damages should be applied.
Well, let's hear from the other side.
Okay, thank you.
Please, the court, I'm Duke Mcdaniel, and I've been down to the court since 1964. It's a pleasure to be back here with you all. Miss Chappell did an excellent job, but oddly enough, she is not familiar with the real circumstances in this case. The case began in 2010 on a condemnation suit. The road was built. After the road was constructed, my client came to my office and said, Mr. McDaniel, we're landlocked. We can't get into our property. I notified the state of West Virginia of that fact. I sent them notice. They did not take that at face. So I then hired a surveyor upon behalf of my client and had the whole tract surveyed. I then submitted the survey to the Department of Highways, and it wasn't until late in the year of 2014 I took the state's attorney to the property and said, here are the keys to my truck, find me an entrance to this property. You all are saying it isn't landlocked. There was no entrance.
Well, how'd you get into it?
There was no entrance to the property.
You said you took him there, though.
I took him to the area of the property.
Oh, okay.
The area of the property. There was a road that went into that property called the Old Morrissey Road. It was completely destroyed. Old Morrissey Road no longer exists. Then, evidently, Mr. Athey, who represented the state of West Virginia, contacted the state, and he went up then on October the 9th with Mr. Kiesecker, the state's appraiser. They made a visit on October the 9th. Now, if you'll notice in your materials, there is a very important document to me and to my client called the Kiesecker letter. Kiesecker then on January 15th of 2015 writes Rick Eldridge of the state of West Virginia, who is in the right-of-way division, and you'll note in that letter that he acknowledges at that point in time the land was landlocked. There's no question whatsoever that the land is landlocked. What was the obligation of the state of West Virginia at the time they learned the land was landlocked? They decided to do nothing. So I became proactive in the case. I went to the Dotson case. What does Dotson say? If the land is landlocked, then you file a motion to amend and then file a counterclaim in the suit. I did this. I amended, asked to amend my complaint, file a counterclaim. It fell on deaf ears of the court. The court says, oh, no, no, no. This isn't going to happen because the state's already condemned this property. I said, Your Honor, if you look at the legal description in the condemnation proceedings, the 128 acres was not condemned, was not a part of the original condemnation petition. Never mentioned in the petition. So with that, we get into a negotiation with the new attorney for the state of West Virginia, who becomes Anthony Rogers, and he said, well, let's go up on the land and take a look at it. And we did. And if you look at the Keysecker report, where Keysecker says the road can be built between station so-and-so and so-and-so, there's a 25-foot bank sitting right there. There's no way to build the road. They have a spur road into another property, and they said, well, we'll come off this road. The area that they're proposing to construct this new roadway is in a slide area on the project. There's a tremendous riprap area of stone that carries the water off the top of the mountain right down adjacent to this property. Now, my position at the court was this. I said, Judge, the land is landlocked. What does this mean? Well, you look at the federal statute, and the statute says if it's an uneconomic remnant, which we're saying here, that the commissioner would make a determination as to whether or not it was landlocked. Moot question. It's landlocked. Keysecker's report, their own appraiser says it's landlocked. But he says, oh, we can go to station this and station that and build a road. No, no, no. What is the procedure? If they knew the land was landlocked, they should have hired Keysecker to do an appraisal on the property and assess the damage to the residue, if any, to that acreage, which my client owns and can't get to. Or he would have had to put in his appraisal, what is the cost to cure? You look at Keysecker's appraisal, it says nothing. I asked the state of West Virginia, I said, well, you know, why don't you have Mr. Keysecker, oh, this is Keysecker's appraisal. This is what we're going to use at trial. I said, what? And we're going to build this road in there. I said, well, interesting point. We go out with the county engineer and a couple of right-of-way agents, and we stand there for about 20 minutes in this area, and they say, well, we're going to build an access road in there, and it's going to cost us $100,000. I said, gentlemen, you just don't do that. If you're going to build an access road, you have to have plans. You have to have monies appropriated for it. They said, well, we're building it on our own property. The fallacy of that is they have to go across my land to get to the property, and without his consent, they can't touch it.
Well, the lower court's answers to the certified questions are consistent with your position, correct? Is that correct?
My position on the certified question is that the state of West Virginia, when they landlock a parcel of land, cannot bring a state engineer in before a jury and says, hey, we can correct this by just putting him a road in, and it's going to cost us $100,000.
Well, the lower court said that the landowner could reject an alternative road, correct?
No, the lower court said that it would be go to the jury for mitigation of damages. That the state.
Well, that was the second part. That if it was rejected, they could introduce that as.
Oh yeah. If we reject it, what the court has said is the state could come in there and present evidence that you rejected it, and that road is going to cost $100,000. They can't do that. I mean, the landowners under West Virginia law. And Justice Jenkins has addressed that. There are numerous cases that says that they are to be paid by just compensation. They're to be paid money. The Constitution of the state of West Virginia provides that just compensation. The Constitution of the United States provides that just compensation. Now, if you look at the cases that have been decided by this court, there have been about 5 cases. Justice Jenkins mentioned one of them. But in the Baltimore and Ohio Railroad case, it was an old case. In that, they were building a railroad. And they condemned. And what they wanted to do to mitigate their damages, they took away the water supply. And the Baltimore and Ohio Railroad says, oh, well, we'll just put the water line under the railroad. Landowner said, I don't want that. You know, I'm entitled to just compensation. Court says that you're entitled to just compensation in money damages. In your Schaefer case that you mentioned, compensation must be paid in money. Black letter law, no question about it. And they, in that case, similar to this case, they wanted to trade an easement in some of the consideration. To me, giving the Department of Highways the right in this great state to mitigate damages in a case that after the road has been constructed is a violation of everything we have in this state.
So, counsel, again, let's walk through it step by step.
Yes, sir.
You don't challenge the authority under 42 U.S.C. 4651(9) for the commissioner to deem an uneconomic remnant.
I do not challenge that because it follows the federal statutes, and the commissioner, by receiving the letter of Fiesecker, it has been determined that it is an uneconomic remnant.
So step one, commissioner has sole authority to decide that.
Yes, sir.
Step two is, assuming that decision is made, the question is, do they pay the respondents the appraised value, however it's calculated, for the remnant, or do they have the authority at their discretion to come in and mitigate by putting in a state paid for, and the state just acknowledged that that includes maintenance for the future? Doesn't the highways have that authority if deemed uneconomic remnant?
They do not
make that decision?
They do not. There's no provision in the federal statute that says that. They shall be paid for their uneconomic remnant, which means money.
Is there anything in the federal statute that says, in this case, the respondent has the right to reject the state's decision to put in a new access road and force the state to pay the residual value, the appraised value of the entire landlocked property?
Federal statute says this: if there was no condemnation, which there hasn't been on this remnant, that they need the landowner's permission. Okay, that's in there. Now, our lower court had the right to ask the state of West Virginia to condemn the property. And another thing that isn't in this record, I also brought a mandamus against the circuit court asking him to condemn.
Let me ask you, you said subject to their permission. So if the DOH came back after deeming uneconomic remnant, we want to put in this road. I understand quarter H, I understand the hilliness nature, and a key element of your argument. But you're saying in any circumstance, the property owner would have the right to reject any plan offered by DOH and force then DOH not to do a new road, but to pay. And this was a number of acres that are the remnant.
I agree.
And so you say it's within the complete discretion of the landowner to reject the DOH's offer for mitigation and force the DOH into paying the fair market value of the remnant land.
Your Honor, if you look at the case law in West Virginia, the case law says that they shall be paid in money only. This has been attempted in West Virginia before. A county was condemning some right-of-way. They wanted to build a big hard-cap road up to his place. The court said, no, you can't do that. This could run either way. And I think the protection of the coffers of the state of West Virginia says that you pay money damages. That's what the Constitution says. You can't make trade-offs or political deals to build roads and do this and do that. That's why in the Wayne County case, the court said, no, you can't build him a hardtop road. In the Heron case, they wanted to build a fence. The court said, no, you can't build a fence. You've got to pay people money damages. So I'm saying the federal statute, in answer to your question, does not specifically give the landowner the right to reject building it right away into their property, but there's no case law in West Virginia that gives the Department of Highways that legal right. And I'm saying to you that I feel that we have, in the trial and preparation of this case, we've attempted to use the Dodson case. We've attempted and asked the court to have it condemned. I filed a mandamus action, and to me, the state is out there with an appraiser that's saying, you know, it's landlocked. And they even say it's worth $261,000. We have sat there for almost 10 years without a cent of money. I asked the court at one juncture, I said, it's an uneconomic remedy. What does it say if the state is going to use any property in the state of West Virginia for public use? They got to make a deposit into court. I asked the court to have them deposit into the court the $261,000. No deposit was ever made. I'm sitting here with a 92-year-old man that's land's been taken and nothing's been done by the circuit court.
Just to ask you one question about not the residual property that's landlocked, but the property that was condemned for the road project originally.
Yes, sir.
When that was condemned, was there any anticipation of a access road off of that road into your property or into the property that was landlocked? I mean, in other words, if they were going to build the road, they would have to have some access across, I assume, the original property to get to your landlocked property, right? And was there any language in the documentation under that original condemnation that would give them that right to do that?
The original condemnation, and if you look at the plans, they show what was known as the old Morrissey Road going into the property. That is where they said it was going to go. In good faith, the state did not know the land was landlocked or would not acknowledge that fact until I spent over $4,000 getting an appraisal done, or a survey done to show it. When we went up, the Morrissey Road was completely obliterated. There's nothing there. So my clients absolutely have no way to get to that property unless they go through an access road which goes to another property that the state created for a house that's up above the property.
So they would already have the right to build the road as far as an easement, right? But they just...
The state would, but on our property, no. I mean, where they're going into this area, it's my person's property.
And that wasn't part of the original condemnation?
Absolutely not, Your Honor. Absolutely not.
All right, thank you.
Thank you, ma'am.
How about a very brief rebuttal?
I just want to clarify that in any condemnation, the state, by statute, is only permitted to condemn that property which it presently needs for public road purposes. That's 17-2A-18. The state can only acquire property that is not presently needed for public purposes by means other than condemnation. So the suggestion that the residue should have been included in the condemnation is just inconsistent with the law, and it's not how it's done. What happens is the appraiser appraises the entirety of the property, puts a value on the part taken, and then, if in the appraiser's opinion there are damages to the residue, assesses that and includes it in the estimate of just compensation. If there is a dispute as to just compensation for damages to the residue, that is addressed in the witness's testimony at trial. Each appraiser presents, or each side presents their evidence as to the appraiser's valuation and how much of that should be applied to damages to the residue. I would ask that the court take a look at my brief with respect to reformulated questions 4 and 5. We have touched on those topics, but I haven't gone into them in detail. And I think the subject of a cost to cure comes up in this case and will end up being an issue at the trial of this case. So if an alternative access is constructed, again, to make it clear, the property owner is still free to take the position that there are damages that apply to the residue in the amount that the expert witnesses deem appropriate. Thank you.
Thank you very much. This case will be submitted.
Thank you.
Moving now to the Rule 19 argument docket, Jonathan E. Presnell Sr. versus Aston J. Presnell III and others, docket number 170857, and this is an appeal from the Circuit Court of Mineral County.
May it please the court. Good morning. My name is Tyler Roball. I represent the petitioner, Jonathan Presnell. I'm from Nelson and Michael's Law Office in Kaiser, West Virginia. A little background into this case. This was a three-part complaint brought in the Circuit Court of Mineral County, West Virginia. The part that deals with this appeal is the partition suit, which stems from the estate of Rosella Presnell and her will devising an approximately 300-acre family farm in Mineral County. The respondents brought forth a motion to sell 2 parcels out of this 300-acre family farm in the spring of 2017. The petitioner also filed a motion to appoint commissioners in the partition suit around the same time. This was brought for a hearing in June 2017, in which the Circuit Court ordered that it granted the motion to sell the 2 parcels out of this family farm. The issue in this case is whether this devise of the family farm was a specific devise, and thus whether the court erred in not following the procedure for partition suits outlined in West Virginia Code 37-4-3. The first issue is determining whether this was a specific devise. Black's Law defines a specific devise as simply a devise that passes a particular piece of property. Clearly, the devise of the family farm falls into this category. It names the acreage, approximately 306 acres, the location, Middle Ridge in Mineral County, and also the description of the family farm. What it also does is distinguishes it from the other property real estate contained in the estate, which would be the homestead as well as the commercial property. Now, this court in Patton versus Cooley, an older case, stated that a specific devise vests immediately after the death of the testator unless intent is clear that title is to be delayed from vesting. Here is where the lower court erred in their determination of the vesting of the property. The lower court relied on the general power to sell as well as language contained in the specific devise of the commercial property and homestead that laid out guidelines for how the property's proceeds would be divided if the property was sold. First, moving on to the general power of sale. West Virginia Code gives us insight into that in 44.8-1. When the executor is giving the general power to sell, it allows him to sell the real estate in the estate, except for any specific devises. And as I stated earlier, the family farm is clearly a specific devise. Now, moving on to the language that was in the specific devise of the homestead and the commercial property. Not only was this language of how the proceeds were to be distributed not present in the paragraph containing the specific devise of the family farm, it also is not a devise that states that title is to be delayed. It merely offers a guideline. That's why it starts with if the property is sold. It's a guideline for the executors to follow if the commercial real estate is sold. There is no language in there, and it's definitely not clear that title is to be delayed. There's no contingency, no situation when the title of this property is to be vested. Moving on, if vested immediately, then this circuit court sold his property interests without giving Mr. Jonathan Presnell due process. Under West Virginia Code 37-4-3, there are 3 factors in a partition suit to determine whether the property can be sold. The lower court, however, did not even get past the first factor, which is that the property must be found to not be able to be partitioned in kind. This court in Robertson v. Coleman, a seminal case from about 150 years ago, required an inquiry from a commissioner with findings on the record of whether the property can be partitioned in kind. Further, that case stated, where the record does not show these findings, a sale is erroneous. As I stated earlier, the petitioner, Jonathan Presnell, filed a motion to appoint commissioners. However, that motion was denied, and the court proceeded on with granting the motion to sell the property without ever having any findings on the record, any commissioners appointed to determine whether this property could be devised. For those reasons, being that this was a specific devise and that title had vested, the court basically circumvented Mr. Jonathan Presnell's due process rights and his property interest in this property by not following the partition statute, by not determining whether it could be partitioned in kind. This interlocutory appeal is proper for a collateral order doctrine to fix this error from the lower court. There are three factors to determine whether this court can grant a collateral order in an interlocutory appeal. The first is that the order from the lower court conclusively determines a disputed controversy. Here in this case, in essence, with this court's granting of the motion to sell, the partition suit is over. There is some language in the transcript that the lower court would like the parties to partition in kind the rest of the property. However, that would directly contradict the order that is on appeal today. In essence, by granting this motion to sell, even if it is two properties of a 300-acre farm, it's giving the executives the power to sell the entire real estate, because it's in essence saying that Mr. Jonathan Presnell's rights have not vested. So if it was to proceed with the partition in kind, it would be a direct a direct contradiction of this order today. The second factor is that it resolves an important issue completely separate from the merits of the case. This is a procedural issue. I'm not here today to ask the court to determine whether this property can be partitioned in kind. That's the lower court's decision. What I'm here today to ask for is that this court reverse the lower court's error of not even following the first step of the procedure in a partition suit. And finally, that this order is effectively unreviewable. This case will continue after this court has made its decision. We still have two more parts of the complaint to deal with, so this case could go on for months up to a year. So if this court does not overrule this decision, this property will be sold. The lower court has placed it on a stay to indeterminate of whatever the outcome of this case is on appeal today. So once that property is sold, it will be in the possession of the buyers for months, if not a year, until the final order. So to try, at the final order, to try and review and overrule this error today, even if it was overruled, Mr. Presnell would have a difficult, if not impossible, task of not only getting it overruled at that point, but setting aside the sales. If this court determines that there's not enough facts in this case to warrant a collateral order, we would ask this court to issue a writ of prohibition, as there is enough evidence to support a writ of prohibition. There are 5 factors that allow this court to grant a writ of prohibition. The first is that there's no adequate means to obtain desired relief. This is similar to the last factor I described in the collateral order doctrine. If this case is sent to the final order and then it's appealed, then in essence would be it would be a disadvantage for Mr. Presnell, as he would be unable to seek the remedy that I am seeking today, because the buyers will have owned the property for months, if not up to a year. The second factor is that Mr. Presnell will be damaged or prejudiced that is not correctable upon appeal. Not only will it be impossible, if not difficult, if not impossible, to set aside these sales on a final order, if these buyers take immediate possession of this land, that gives them the free rein to not only develop the property, but timber the property. So even if this court on a final order was to reverse the lower court's determination and send it back to a partition suit, these buyers will have the property and be able to do whatever they want. And an order from this court and even a correct order from the lower court would not be able to reverse the physical changes that the buyer would be able to make to the property on a final order if this lower court's order granting the motion to sale is able to go through. The third factor is that it's clearly erroneous. If this court finds that it is a specific devise and that it vested, the lower court's decision to not follow the partition statute 37-4-3 is clearly erroneous. Because in essence, it is circumventing Mr. Jonathan Presnell's due process rights in his property by not determining if it was able to be partitioned in kind. The other two factors are not in play in this case. But however, this court held in State Ex Rel v. Hoover that not all factors are needed to issue a writ of prohibition. And that they also stated that the third factor, clearly erroneous, is to have the most weight in reviewing whether the writ is proper. And for those reasons, as I previously stated, we would ask this court to either under the collateral order doctrine or as a writ of prohibition overrule the lower court's decision to not apply 37-4-3 in regards to a partition suit. Thank you.
Thank you. Let's hear from the other side.
Madam Chief Justice, Your Honors, and may it please the Court, my name is Ramon Rosas. I represent the executors in the state, Mr. Presnell and Mr. Wolf. It is our position, Your Honor, that the question you really have to address is, did the circuit court abuse its discretion in making the factual finding that the intent of the testator was not to provide a specific devise? I believe that when you read the transcript of the circuit court's decision, that the decision the circuit court made was a factual one, that the intent of the testator, which is the paramount rule under West Virginia law, was to not provide a specific devise, that the intent of the testator was to allow the personal representatives to sell any real property or personal property and to divide that monies if the sale occurred amongst the heirs as described in the will.
Well, what language in her will indicated that it had to be sold? I thought it said, in the event that any or all of this is sold.
There's two parts, Your Honor. One is the general authority under the fifth paragraph, and that's page 10 of the appendix, the fifth paragraph, where the executors are authorized and empowered to sell any and all property in the estate. And we would, as the circuit court did, we would point to the language in B, and where clearly the testator considered the possibility that the personal representative, the executors, would decide to sell the property. If it was a specific devise, she would not have designed a scheme to deal with the monies that might arise from a sale. If the factual finding of the circuit court is correct and her intent was not to commit a specific devise, then there's no question about whether there were violations of the partition statute or whether any due process rights were violated, because there's no specific property right that vested to Mr. Presnell.
I want to go back to your statement about the circuit court making factual findings. Did the circuit court take any evidence?
I don't believe there was any evidence, Your Honor. The only evidence
there was not a hearing. There was not testimony, correct?
There was no testimony. The only exhibits were those that were presented at the court, both in the exhibit and in the motions, and I believe are included in the appendix.
Well, I don't see any findings in his orders to the effect that you stated.
Well, I'm pointing to the transcript, Your Honor.
Well, but I'm looking at a court order. Transcript, if you made an order, it should be incorporated into the written order.
Well, I understand, Your Honor.
Especially when there's a significant issue like this.
I understand. Often, I'd simply say, Your Honor, that often there are, often that the orders represent and may indicate, and I don't have the order directly in front of me, but may indicate that the rulings are more clearly laid out in the oral transcript.
Well, the order doesn't say that.
Well, I understand, Your Honor. I would point to the circuit court's specific finding, and that's at page 124 of the record, line 17, So I'm going to find, even though there are some specific bequests, there's enough language that implies, and Ms. Presnell anticipated, the wanting to sell or allowing the executors the right to sell all or part of this real property. That was a specific finding.
You all should have got that in the order, or at least you should have.
I was not counsel below, I can say.
Well, whoever it was.
I would point out, Your Honor, however, that was a finding the circuit court made. It's on the record. It's our position.
Well, the court speaks to its orders.
Yes, ma'am.
I want to go back to the "in the event of sale" language that you're relying on. Isn't that language related to the commercial property and not the family farm?
I believe when read in connection with the general power to sale, that it shows the general intent of the testator, Your Honor. As the Hope Gas case indicated, Your Honor, when a court looks at the intent of a testator, it is supposed to look at the general overall intent of the will over any specific language contained therein. In the Hope Gas case, the testator had left property to an heir who was, at the time of the drafting, was childless. There was a codicil added later that when a child was born, however, there's some language in the codicil that conflicted with the will. The court found that it was clear that the general intent of the testator was wanting to take care of the child, and so they read out the codicil language that broke with that general intent. In this situation, Your Honor, we believe when you read the general clause empowering the executors to sell all the property, and that clause setting up a monetary scheme specifically for that set of property, it is clear that the testator intended the executors to be able, in their discretion, to sell property.
Or could the testator simply have foreseen that the commercial property was not amenable to partition in kind and just included that language with regard to the commercial property and not the family farm?
That is a potential reading, Your Honor. However, I would point to three things. One, the general power that she gave the executors to sell all of her property. Two, the fact that she did not specifically indicate in the will that this is a specific devise and I intend this land to go outside of sale. And three, we believe that's a factual question that the circuit court answered, and that we don't believe the petitioners can demonstrate that that finding is an abuse of discretion.
Well, just because a testator gives authority to sell, if they, in their discretion, that doesn't mean they're mandated to sell.
That's correct, Your Honor, but then that's just in the discretion of the executors.
But the executors of an estate have a fiduciary duty to all the beneficiaries.
That's correct, Your Honor. And while there's a lawsuit, where there's a clause about breach of fiduciary duty in the lawsuit, that hasn't been reached. It would be our position, Your Honor, for example, were the executors to sell the property in a non-hands length deal for substantially less, that would be a breach of fiduciary duty. But
I don't understand why they didn't, well, I don't know all the facts, but I was going to say I don't understand why they didn't go through the partition examination criteria.
I can tell you, Your Honor, there have been some practical problems with it. And again, this isn't in the record.
That's all right. I shouldn't even brought that up.
That's fine, Your Honor. But if the executors sell the property at fair market value, and the property and the monies are distributed equally, or as described in the will, not exactly equally, but equally, then there's no breach of fiduciary duty, and the executors have carried out their duties, have dealt fairly with all the executors, and have carried out the will of the testator.
Any other questions? Okay, I think we understand.
Thank you, Your Honor.
Do you have any rebuttal, sir?
I'll be brief, Your Honor. To the first point, in regards to the general power, most wills have a general power of sale, and that's why we had the 44-8-4 code that states that a general power of sale does give the executors the right to sell property unless it's been specifically devised. And then I'd like to point the court's attention to is paragraph 4 of the order from the hearing in June, dated August 29, 2017, where the court states that reasons that language in paragraph 7 further demonstrates that Mrs. Presnell envisioned that her executors might sell real property that had been specifically devised. So here we have the lower court maybe fixing the error of its language, saying that there was some specific bequest in the transcript, and now saying that this was a specific devise. And without a clear language that's delaying the specific devise, it vests immediately upon the death of the testator. Thank you, Your Honor.
All right, thanks to both of you. This case will be submitted.
Thank you, Your Honors.
At this time, the court is going to recess and will reconvene at 1 o'clock this afternoon.
1:30.
1:30 this afternoon, I apologize, Chief. So the court will recess, reconvene at 1:30.
Please stand while the justice regroup.
And I guess they're coming up around noon from the legislature. I'll give you a call in. Oh, 11? They ain't in yet. Yeah, I'll give you a holler when they're in. Thank you, sir. Yeah. We're going to say the house is coming in first, right?